Welcome to another episode of Hebrew Interviews. Why don't you like, subscribe, share if this is your first time with us? And of course, if you are with us already, why don't you call a friend? Let a friend know that we are on and it's going to be something special. Yes, it's going to be a special interview with Mrs. Patricia Richardson, solicitor, to tell you how to keep more of your wealth. More of your wealth? That I ain't got none. Well, you'll have even less of none if you don't listen into tonight. We welcome you as our audience. And of course, we welcome our guest, Patricia Richardson, whom you'll meet in a little while. We try to find interesting people with interesting skills in our community to interview about important topics or issues that face our people. And this tonight is one of them. The issue of wills, probates, power of attorney, and general asset protection is an important issue that is dying. Literally needs to be addressed within our community, that is the melinated community. And why does it need to be addressed? Well, we have been operating by word of mouth and somewhat outside of the realms of the law's protection. And what's happened is many generations, I say many generations, especially the generations from the who are here 40s, 50s, 60s, 70s, have lost a lot of our assets and have not been able to pass it down because there was little or no estate planning. Well, I do have a disclaimer. What's your disclaimer? My disclaimer is we are not expecting to cover every single detail and every single thing or every legal loophole or issue. We're going to cover some general issues and give the opportunity to you to ask some questions. If you have questions, please post them soon as you have them, and my moderators will pick them up and will feed those through to us so that we'll be able to ask them of our guests and have them answered before the end of today. But today we're going to hear from a qualified solicitor. In fact, between you and me, don't tell everybody, she's qualified to the High Court. So if she don't know what she's talking about, we're in trouble. But fortunately, she's not a woman to mess with. She is not a woman who plays. She's very, very serious. So you can call your friends now. Call your friends. Who have we got here thus far? Because we seem to be a bit slow to warm up tonight. Well, I say welcome, Sister Yvonne, Sister Judy. Welcome, Sister Carol. Call your friends, call your family, send them a text, tell them to sign on and to be with us because this particular topic is importante, very importante. You can't afford to miss it. To my wife, I said, didn't you say your sons need to hear this, honey?
I told them.
Oh, she's told them. She's told them, right? So we're going to make a start. I'm going to introduce our guests now. Oh, I'm playing for a little bit more time. I want you to know that our language class on Thursday a.m. early, we're going to change some things around. I've had a little dialogue with the boss, and I believe he's told me that I need to change the PEG system to make it simpler because some people are struggling. And then what should happen? I picked up the phone talking to someone. She said, well, I'm struggling with the PEG system. And I said, that confirms what the Most High has said to me. Somebody make sure you contact Sister Susan as well. Yep, she needs to be on this one. Talk to folks. Get that text finger going. Tell somebody, invite somebody. If you're on Facebook, You need to follow me as Dr. Trevor Dennis, but invite somebody. Send that link over. If you're on YouTube, do the same. If you're on Twitter, Twitter it to somebody. Whatever it is that you need to do to get your family members on the same page as you, literally, the YouTube page, get them here. Get them here. Thank you, thank you, thank you. Welcome, Sister Yahweh. Welcome. We appreciate you coming. Yes, indeed. So, I think it's time I introduce my guest. Here we go. Today, you're going to hear from Mrs. Patricia Richardson. Hello there, Patricia. Say hello to
good evening. Good evening to everyone.
Right. Well, my first question is this. Can you tell us about Patricia Richardson, the person? Introduce yourself to the world and tell them something about the woman Patricia Richardson, the professional Patricia Richardson, and your family. Go ahead. Over to you.
Oh gosh, right, okay. I wasn't expecting this to be the starter, but I'm happy to do so. Well, I've been a qualified lawyer since actually about 1993. So that's coming up, what is it, about 27, 28 years. For many years, in fact,
stop. Did you qualify out of school? Because you still look very, very young. For you to look
see, that's the answer. That's what I usually like to hear. That's what I usually like to hear. Yes, I have been qualified for a long time. The majority of my career actually was spent as a criminal lawyer. I was a prosecutor, a chief crown prosecutor, which, if no one knows, it means that it was basically all criminal work. And then about 10, 12 years ago, I decided to, what I say, leave my life of crime behind me and to start on my own. And it was very, very important to me, just because of my own family circumstances, that I concentrate on helping people to manage their estates post death, in particular. And in particular, that is people from my own community whom I found were always very reluctant to talk about what happens after death, and are generally extremely private people. So I made it a bit of a mission to try to inform members of the community, particularly about how important it is to sort your affairs out. Yes, of course, I know we want to be private, but as Trevor said at the beginning, unfortunately, particularly, and I know we're talking to people from all parts of the country, but particularly in London, a lot of the members of the community who are getting on in age are often in properties that are now of quite high value. And what I found was that they were losing out, missing opportunities, paying lots of tax as a result of not sorting their affairs out beforehand. So that's me professionally. Personally, I have a family. I'm married, live in London with 2 children. And what do I enjoy? I enjoy eating out, and even more so now that we can go out and garden.
Well, I know that you run your own business. You run your own practice. So what kind of products do you generally offer?
I do what they call private client work. When you're a solicitor, you generally do specialize in a particular field. As I said, for 20 odd years, I was a prosecutor. Now I do what's called private client work, and I focus on wills, on probate. So that probate is the process after somebody's passed away in order to tie up their estate. I also am very interested in mental health issues, and particularly elderly issues. So I also handle and prepare lasting powers of attorney that we may be able to touch on today, Also things called deputyship orders in relation to the court of protection. So those are sort of the mainstay. But then as a solicitor, often what happens is, you know, someone will come along with one particular issue, and invariably there'll be other issues that they want to. And so I will generally, hopefully, be able to assist them with any legal matter, most legal matters, or refer them on if need be.
So when did you first become aware of the general problem that melanated people have in protecting their assets?
Sorry, say that again. When did I first become
When
aware?
did you first become aware of the problem of melanated people not protecting their assets very well?
Well,
When did it come in personally?
it was more, I think, it's for many years actually, just from my own family circumstances and people known to my family and situations that had occurred. And then when I set up, I was quite surprised at just how many people were contacting me, mainly adult children who needed their parents to speak to someone because their parents wouldn't listen to them when they were saying that you need to sort things out. So it was around about that time. So it's been many years I've been aware that there's been a problem, as I said, because I think all of us melanated people know that generally we keep our affairs quiet and private, and which is always obviously a good thing, and I'm an advocate of that. But unfortunately, in these circumstances, being too private can actually cost.
So what roadblocks or detours might somebody encounter in terms of financial planning if they don't have one? There's so many people that don't actually have a financial plan for their family, and then something goes wrong. What kind of...
Yeah, well, I mean, I'd say this. I'd say, leaving aside, of course, there are issues when, well, there are two types. Firstly, one of the big issues that we know, I think most people will possibly know someone in the position, is where a elderly relative, or, you know, sometimes not so elderly, falls ill. Falls ill, I'm not talking about death at this stage, falls ill, either is hospitalized or has some other type of, like, dementia, which we know is all too common. So I'd say the majority now of phone calls I get are, again, adult children who contact me to inform me that their parent has been diagnosed with whether it be a stroke or whether it be dementia, and we don't know what to do. We don't know how to access her money. She's got these bills to pay, this to pay, that to pay, and we don't know what to do. And this is where often the situation is that had they taken action beforehand in terms of a lasting power of attorney, I wouldn't need to get that phone call because everything would be sorted. But invariably, I then get that phone call. And unfortunately, if someone has lost mental capacity, they can no longer make a lasting power of attorney. And it then means that we have to go to the court of protection, which can take almost a year to get an order for a deputyship order, which costs a lot of money, and meanwhile essential financial matters relating to that person are not being dealt with. So that's one issue. That's when you're still living. The second, obviously, is in relation to a will, and again I will probably come more onto it, but it's where individuals don't make a will and they die in what we call intestate. And what that means is that their estate will be shared amongst a certain category. It's usually spouse, it's children, etc. And that may seem fine, but from my experience, I often, when I speak to my clients, I'm told that they may have, particularly a certain generation, children back in their home country that they've never had any contact with for many, many years, may have left them as a child, or what have you, may have married, remarried, etc. If you die without making a will, a child that you haven't seen for the last 40 years has as much right to your estate as a child that you had been looking after for the last 40 years and may have helped in your care. So it's things like that that need to be addressed by making a will and making a power of attorney.
Okay, so you've touched on a will, so let's start there. What is a will?
Right, a will is a document. It's a legal document if it's drafted properly.
Sorry,
That
and why do we need
allows
one?
the.
What is a will, and why do we need one?
Why do
Why is
we?
it so important?
Right. Okay. So yeah. So a will is a legal document that allows a person, each of us, to say what we would want to be done with all the assets that we have acquired throughout our life, who we want it to go to, and in what circumstances we want it, i.e., you know, it may be grandchildren at a certain age, etc. It's a legal document. And once made and once it's actually been executed properly, it has to be dealt with by the letter. So it's not that someone can do something different, they have to go with your wishes. Now, why should we have one? Really, it's a bit of what I've touched on. Firstly, it gives you, bearing in mind, you know, hopefully we're going to live for many years. If you think all throughout your life, all of the work you do, how many hours a day people have worked throughout their life and built up what can be, whether it be a small amount of assets or a large amount of assets, it doesn't matter. The fact of the matter is you will have worked for that. And it's important that you are able to say, all that I worked for, I want to decide who it should go to. Failing which, if you don't do it, you don't get to decide. It is the court that gets to decide. Secondly, making a will can also be more cost effective in terms of the tax that's then put on the estate on your death. So if you make a will and you actually set it, you know, speak to a legally qualified solicitor, you can possibly reduce the amount of inheritance tax that would have been placed on the value of your estate had you not made a will. So it's about planning. It's about trying to reduce the amount of tax that your family has to pay. And it's also about being able to say who you want the goods to go to. The final thing is that I should say that, you know, one of the cases I've dealt with was a gentleman who had no children, had not made a will. And in those circumstances, we couldn't find any family still living. And it was the Treasury that ends up getting all of the assets that he built up over the years. And I always think that that's a travesty, that you
Yeah,
would have worked all those years, paid all your taxes, and then at the end of the day, it's still the state that gets all that you've worked for. So those
wow,
circumstances, you must be important to make a will.
wow. That is awful to think he worked so hard, died, and then left it to the government. That is awful. So just tell us for a moment, how should we or how can we generally go about making a will?
Right, there are a number of options. Obviously, I would say, you know, the best option is to see a solicitor. Of course, I would say that. People can make their own wills. Unfortunately, and sorry, I haven't come here with the statistics, but there are a number of wills that actually, when someone passes away, are then deemed to be invalid. And so someone will have made a will, and the vast majority of those wills are wills that people have decided to write themselves. Because even though people think that, oh, I haven't got much, actually, you know, some people just sort of literally write down a few words. I want to give this, that, and the other to whoever. There are certain rules that I will come on to into making a legally bound will that they will not have considered. And also in terms of the tax situation, they will not have considered other options that may have been available to them that could have avoided tax. So yes, you can write your own will. And the second one is to go to a solicitor to have a will written. I would say the majority of people, a solicitor's will is going to be better, knowing, yes, of course, you will have to pay for it, but it could save you thousands of pounds in the future, or your estate thousands of pounds in the future.
So, what are the key points of a binding will then, that being the case?
Right. Okay. So there are a number. Firstly, at the beginning, and I think these are the words that probably most people will have heard, I revoke all former wills. And that's the first thing, because any one person must only ever have one will that is valid at any time. So you can't, if you've made a will previously, that is invalidated by any new will that you write. And so we formally set that out at the beginning by ensuring it says that you revoke any other will that you've made previously. The second thing is that you must name the people, and this is the term executors. You must name the people that are going to manage your estate for you. And when I say estate, it's important, and a lot of people often think, oh, I haven't got much, I haven't got an estate. That is just a legal term, and all it means is what you own, okay? So everybody has an estate, even if you've just got a shoebox, you've got an estate, and it's your shoebox that's your estate. So you have to name the people who are going to help execute, and that's why they're called executors. They're going to manage the process when you pass away to ensure what you've said in your will gets done.
Mm-hmm.
You're then going to have a number of gifts that you may wish to give, and that can be from a typewriter to, I don't know, a book. And then after that, it's very, very important. And just recently, I've been dealing with a case where a will was written, and the person has now passed away, and the will didn't deal with what we call the residue. So they gave away a number of gifts, a property, or this or that, but whatever was left, they didn't deal with. And so what we call that is partial intestacy. And it just so happens in this particular case that the person who I know specifically didn't want her spouse to get any of her estate. He is now going to get half her estate because the residue wasn't dealt with. The residue, it means that everything else you own that's not already accounted for, you decide who that should go to. And finally, and obviously there's a number of other things, but I'll just tie this up with finally, one of the most important things about a will is that it's signed, and that it is signed in front of two independent witnesses. And can I say this is often the cause of an invalidated will, is that it is not what we call attested correctly. And attested correctly means that it must be signed in front of two independent witnesses who are not going to benefit from your estate. So often people will do things like they're giving their property, they're giving their estate to their child, and their child witnesses the will. Well, that invalidates the will. Okay. So that is absolutely important. Sometimes I see cases where there's only one witness being present. And there's a famous case that has gone down in precedent where someone objected to a will. And when the witnesses were called to court to be questioned about whether all of the criteria had been met, one of the witnesses commented that they weren't in the room, although they were just outside because they had a phone call, and they weren't in the room when the person making the will actually signed the will. And the will was then found to be invalid as a result, because the law says that it has to be signed in the presence of two independent witnesses. And the fact that someone is nearby is insufficient. They have to be present. So those are the bare bones, I would say, of what needs to be in a will.
Wow. I've heard of a lot of people who have had wills, but the will wasn't signed.
Yes.
And that's probably one of the biggest ones I've heard.
Yeah. Absolutely.
Okay.
There's a myriad of different things that go wrong with wills, which is, why I come back to saying, try to get, yes, it costs money, but try to get it legally drafted.
That does help. So there are a number of principal stores that are used to pass on wealth. So can you just tell us what are the principal stores of wealth that are used to transfer it from generation to generation as you see it? What's your understanding
Principal
of that?
source. I suppose I think what you're getting at is probably trust. So the word principal stores is not something that I have heard before, but it's
Principal
trusts.
ways of keeping, principal ways of storing or
Yeah,
keeping
I get that.
wealth in the family.
Storing wealth. Yeah, I understand. Oh, I understand. Trusts are often used in that way. And trusts are a really good example of this, actually. And if I may, can I give an example of when
Please,
the sort of
please.
most common situation? The most common situation that, again, people think, oh, all I've got is my house. That's all I have. I've got nothing else to give. And so they may well write a will saying, let's take a scenario. You've got husband and wife and a child or two children. And husband and wife decide to write a will saying, no, we just want it to go to the children. Okay. One of them passes away, and they haven't counted for the fact that you can hold property in two different ways. And I don't want to get too complicated, but every one of us who own a property own it as either a joint tenants or what we call tenants in common. And this can become incredibly important when it comes, particularly as we're getting older, and the potential and, for care fees, for instance. So if you've got a husband and wife who held a property jointly as joint tenants, what that means is that when one of them passes away, their share automatically goes to the survivor. So when the wife passes away, the husband owns the property. Now, anything can happen at that stage. Either it could be, and I mentioned care fees, so I'll continue with that. The husband goes into care. As a result, because he owned the property now, because the wife has passed away, the house is now going to be seen by the local authority, obviously, as fully his assets, and therefore it is likely that they will force it to be sold in order to pay for his care fees, which means the two children left, if he lives for many years, and I should say in terms of care fees at the moment, in a residential care home, they're £6,000 to £7,000 a month. So it doesn't take very long for that money to be used up, and before you know it, in fact, there is very little that the children will then inherit. A second option may well have been, all right, he doesn't go into care, but he remarries. The husband then remarries after the first wife has passed away. He doesn't change his will, but because he's remarried, it's invalidated his will. And therefore, he then passes away, and the new spouse is then entitled to the house. And again, the children may well not inherit as much as they should have. So these are a trust, on the other hand. If you had a trust put in place, what you can do, and what my advice often to couples is that you sever the tenancy. So you're no longer seen as joint tenants. You're seen as what we call tenants in common, which means, as far as you're living, it'll make no difference to how you live in the house, but each of you will own 50% of the property. So when one of you passes away, it doesn't automatically go to the survivor. In fact, that 50% goes into a trust. And in your will, you will say, I give my surviving spouse the right to live in that property until their death or until they remarry. And in which case, obviously, once they've passed away, it goes into trust. That 50% will then be definitely passed down to the children. So even if the survivor was to go into care, they only own half a property, and half a property is valueless. And therefore, the likelihood is that the children will then inherit the whole house. Similarly, if they were to remarry, actually, only 50% of the property is likely to then go to the new spouse. At least the 50% of the deceased spouse property will pass to the children. So these are the types of things. That's a trust, and there are many, many different types of trust. But that's the type of trust that was really helpful to, I think, most of us, anyone who owns a property, or even, not just property, but may have money in the bank.
Mm-hmm. Well, I keep hearing about parents who get kicked out of the house by their children while they're still alive. So, any idea of what that's about or might be about?
Yeah, that can be a situation where, again, if you've drafted a will, remember what I said about giving the parent wants to leave the property to the children, and therefore just says in the will, I leave my property to my two children. If there's some difficulty in the relationship, what can then happen? I mean, it's, with being kicked out, it would be an extreme situation. But once that person passes away, the property, their share of the property at least, is then owned by the children and not by the spouse. And that's why I talked about that trust situation where the deceased spouse in the will would be giving to the surviving spouse the right to remain in the property and to use that share of the property for the rest of their life. So they couldn't be kicked out. But if it wasn't put into trust, the fact of the matter is that the children could then own half the property. And having said that, I mean, the circumstances you suggest can also happen, because there are still very, very many couples where what I've found is that the property is solely in the name of the husband, even though they've been married for many years, because it was the practice many, many years ago that women were not seen as equal to be owning a house. And so you'd go to a couple, would go even to get a mortgage, and the house would solely be put in the man's name, and that the wife may never have even known that. And yes, she's working towards the mortgage, etc., but actually the property is not owned by her. So if the husband has then left the property to someone else, she potentially has nowhere to live because
Wow.
she has no ownership over the property. So that's the type of situation that I have seen.
Okay. Well, we've talked a little bit about wills. Is there anything else you want to say on wills before I ask you to explain the difference between wills and something else?
Right. Just to touch a bit on intestacy, really, because again, it's something that is very common. I've told you why it shouldn't. We should try to make a will, but if you don't make a will, then the court decides who gets what, and there's a strict rule that the first value. If suppose your estate, when I say your estate, suppose you've got a house worth £500,000. The first £250,000 of that, the value, is going to go to the spouse, and then the children get what's called half-life interest in the remainder. So they'll get to share sort of about 125,000, and the rest of that going to the spouse. Now, that may not be what you want to happen, and that will be divided amongst all your children. Now, situations I often come across is where, one of the children, unfortunately, of course, we all love all of our children, but relationships can, during the lifetime, break down, and there can be lifestyles that you're not happy with your child. And if you're not making provision in a will, you could find that your wealth or what you owned ends up in the hands of one of your children who actually, is not going to use it in the way that you would have wanted. And I'm talking about people who have addictions or gambling that type of thing. If you're not making provision and deciding who you want to get your estate, then it could easily end up, if you don't make a will, as an intestacy and being passed to people you don't want it to.
Okay, thank you very much for that. So what's the difference between wills and probate?
Say that again. I didn't
What's
catch
the
the
difference
first.
between a will and probate? Because
Right,
many people
okay.
don't understand the difference.
I know, I understand that. And it is, these are all just sort of, terms used. Now, a will is a document, and I said that at the start, it's a legal document where you write down what it is you want to happen. Once you pass away, in fact, the will, I would say, up until you pass away, it is just a piece of paper. Okay? No one can get anything with it. People often think, oh, well, I own this because it's in the will. No, the will is just a piece of paper. Once you pass away, the will has no, you have no way of getting to the assets that are listed in the will. So if someone's left you a book in the will, you are not entitled to that book once they pass away until the will has been put through the probate process. Now, the probate process is, again, it's a legal process where the court get to see your will, and as long as it's a valid will and that the necessary taxes have been paid, they will issue what's called a grant of probate. And that will allow the executors, who I mentioned earlier, the executors in the will, to then actually take almost ownership of your assets so that they can distribute them. Without that probate, they cannot do anything. So an example would be, you've got £10,000 or £20,000 in the bank. The bank, you pass away, the bank will not allow the executors just to come along, show the will and say, oh, here you are, here's the £20,000, and then you can pass it on to whoever it needs to be passed on. That can't happen. What the bank will say is, you cannot get access to this because it's in the name of Mr. Smith, who's now passed away. You cannot get access until you produce a grant of probate. So that will require you to apply. Again, this is usually done through a solicitor, but you can do it yourself. Apply for a grant of probate so that the court is satisfied that there are no taxes to pay and also that the will is valid. And only once you go back to the bank with this grant of probate, with the court seal, will they allow you to take control of that £20,000, and you can then distribute it according to the will. So the probate is the process by which a person's estate is wound up, whereas the will is the legal document that allows them to say what they want to do, what they want to be done to their estate during the probate process, if that makes sense.
And how long does generally getting this probate thing cost?
Probate.
How long does it
well,
take after death?
That's a good question. The probate service, the probate registry, will, I think they say to you that it takes 8 to 10 weeks. My experience is absolutely not. They are, as you can imagine, particularly since the recent situation and number of deaths, they are inundated. They were even before. And it just takes a slight problem with one aspect of the process, whether it be a bit of information that's not given to them. It can take, I would say, anything up to generally about sort of 8 to 10 months in order to get that. I should say, in order to get the estate sorted out, but in order to get the probate, the actual grant, because that's just the first stage, the grant, I would say it takes about 3 to 4 months. And that, it can take even longer if there's some problem. Because the other thing to remember, or that I haven't told you, but you should know, is that you can't get that grant of probate until you've paid the taxes. So particularly inheritance tax will need to be paid before they issue the grant of probate.
Now, hold on there. Hold on there a moment now, Patricia. You're telling me that you have to pay taxes before you have the money to pay taxes, because you've got to get this money out of the bank in order to pay the person's taxes. But you have to pay the taxes before you get the money.
That's right. But the people you will be able to get the money out only to pay the taxes. You can't get it out to distribute it. So and it is a good question. So for instance, yes, the type of thing we would do is, as you know, when we're dealing with probate, we would then be able to write to the bank, show them that the HMRC have requested £10,000 to pay tax, and that will be released in order to pay the taxes. But in order for the executors to then actually hand out and distribute, they can't do that until all the taxes have been paid and the probate's obtained.
Okay, so the government.
And I should also say in relation. Oh yeah, absolutely. And I should also say in relation to property, again, you know, because usually that's the asset that is likely to have the highest burden of inheritance tax. The government do allow you 10 years to pay for the inheritance tax in relation to the value of the property, but they do charge quite a lot of interest every year that is outstanding.
Does that mean that people have to sell the property first before they can pay those taxes?
That is often the case. Often the case that you.
That sounds like daylight robbery.
Many of my clients would like often for the house to stay with the children. Unfortunately, that is often not possible, because if you've got a property, again, you know, in London, it's not unusual for a property to be valued sort of £800,000-900,000. And I haven't touched on taxes, but everyone can give away up to £325,000, a bit more if you're leaving your property to children, but let's just work on 325,000. So anything above that, over the value of 325,000, and that's your whole estate, we're not just talking property, your whole estate is taxed at 40%. So let's just say you've got a property, and I'll use 500,000 just because for ease. So if you've got your estate is worth 500,000, you can give away 325 without it being taxed. 175,000, that's the remainder, is taxed at 40%, which is about £70,000, I think. That works out to, that has to then be found in order to pay off the inheritance tax. Now, it's unusual for people to have that amount of money available to pay it off, and therefore they may find that they have to sell the property in order to release that money so that it can be paid.
Wow. But from what you've said earlier on, you or someone like you are able to reduce the 40%. Is that right? You're able to reduce the percentage?
Not necessarily reduce the percentage. It's about taking action, doing certain things in order to reduce the value of your estate, okay, for inheritance tax purposes. So whether that be certain trusts can be used. So instead of giving someone a gift outright, there are certain options where you put the property into trust, and the property, as a result of being put into trust, isn't seen as part of your estate. And I should say, you know, these are not easy options, and they don't always apply as easily to everyone. So, you know, before everyone thinks, oh, I'll just put everything into trust, it doesn't work like that. And even trust can be expensive because there's a setup fee, a tax when you put it in, there's a 10 yearly tax, and there's an exit tax. So certain trusts can also be quite expensive to run, and you have to weigh up whether it's actually worthwhile. But the type of sort of simple time, not simple, but it's the type of thing would be, and this is where the whole idea of estate planning comes in. So if you're talking about an elderly relative, for instance, if they're in a property that, you know, the family home that's probably got a bit too big for them now, it's actually worthwhile them thinking, as they're getting older, of selling up, buying a smaller property so that they can release the cash. And if they give it away at that stage to their children, for instance, because if though the children are going to benefit anyway, if you give that the excess away to your children, and as long as you last you don't die within 7 years, then that will be tax free. So you could avoid paying any inheritance tax by things like that. So a discussion with a solicitor, or, you know, myself, someone like myself, those are the type of options, you know, the sort of straightforward options we would be talking about when you're talking about estate planning.
Okay. Well, since we're touching on elderly parents, it seems like an appropriate time to ask, what is the lasting power of attorney?
Right. Okay. Well, the lasting power of attorney, I would say, is just as important as a will. And with the prevalence of, as I said at the outset, of, you know, people living longer, they say, and as a result, the types of illnesses, particularly the sort of Alzheimer's, dementia illnesses that are now quite prevalent, it's absolutely vital. A lasting power of attorney, again, a legal document when drafted, it allows a person who still has mental capacity, so you're never too young to make a lasting power of attorney. As long as you have mental capacity, you can decide who you want to manage your affairs if at a later stage in life you are unable to do so for yourself. And it's not just about your property and finances, but it's also about your health and welfare. So there are two types of power of attorney. They're two separate documents, and they are registered. In order to be valid, they must be registered with the Office of the Public Guardian, which is part of the Ministry of Justice and is also linked to the Court of Protection, which I referred to earlier. So these documents allow you to decide whether you want a friend to manage your affairs if you're not able to do so, whether you want your children, whether you want your spouse. And you can also in it indicate the types of decisions you want them to be made to make on your behalf, or for instance, in relation to the health and welfare, what type of care you would like can be stipulated within that document. And I suppose it's you may have heard of living wills, and I just sort of tie this back a bit, because a living will is a document where, particularly around healthcare, your health, so I shouldn't say healthcare, medical decisions, you can have a will that expresses what you want to happen in relation to your medical care in the event of certain circumstances. To be honest, I very rarely, and I don't think I've ever done a living will, I would more likely recommend a lasting power of attorney, because that allows you to cover so much more, and it allows you to give the decision to a loved one, which I think, you know, it's important when doing lasting power of attorney that you decide who is you're most likely to trust to make the right decisions on your behalf. So as I've said, these are legal documents that are absolutely vital, and you're never too young to make one. And once you've made it, you basically have it for the rest of your life.
So tell us a little bit about the two different types of lasting power of attorney, because you mentioned them in passing, but you
Right.
haven't distinguished them.
Okay. So the lasting power of attorney, there's two, as I've said. There's the property and finances, And as the name implies, that allows someone to make decisions when you no longer have the capacity to do so. And I say that no longer has the capacity to do so, but actually, I have had clients who have made one, and whilst they've still got mental capacity, they've just become too tired. They've got to the stage where they don't want to manage their affairs by themselves anymore. It's all become, whether because of their own physical health or, this sort of just the tiring aspect of contacting banks and hanging on the phone and pressing 50 different numbers before you get through to them. So you don't have to have lost capacity to give someone the authority to manage your affairs. And the property and finances allows you to give someone authority to make decisions about your banking, about the property that you live in. So if you wanted them to, they can make decisions even about selling. They can sell the property, your benefits, your pension, anything. I think all of us have been in the situation where if someone tries to ring one of these organizations on your behalf, and they're told, sorry, I can't speak to you, I must speak to the person who owns the account. Mm-hmm. What the lasting power of attorney does is, once you're named as the attorney and the organisation has a copy of that document, they can speak to the attorney as if they were speaking to the person who holds the account. So they have as much authority as the person who is the account holder. So as I've said, it's benefits, it's banking, it's properties, anything related, even your council taxes, anything related to financial matters. Now, the second type is what's called the health and welfare power of attorney. And that allows a person to nominate someone to make decisions about how they should be, for instance, cared for if they're unable to make a decision for themselves. So is it that they want to be cared for at home? Do they want to go into residential care? Is it that they want to, when it comes to medical treatment, often, of course, if you're in hospital, sometimes you have to sign authority to have medical treatment. Your attorney can actually sign that for you if you don't have mental capacity. So again, even in the health and welfare, your attorney can make decisions as to who sees you if you no longer have capacity. So there are circumstances I'm aware of where there was conflict within the family, and it was the attorney's decision not to allow a certain member of the family to come and visit the person who had lost mental capacity. So these are very, very serious decisions, and this is a very, very serious legal document that it takes some care, takes some thought, and takes advice before making one, but it's absolutely vital to all of us to have.
Okay, well, thus far we've dealt with three major documents: the will, the lasting power of eternity property, and the lasting power of eternity welfare and care. Yes. Tongue-tied.
Eternity, yeah.
There is an eternity, but that's a different matter. So, do you handle any other form of investments, asset protection, management, like maybe insurance and maybe even mediation? Are there any other things you have to do? Do you have to do mediation sometimes?
I have done mediation. Yes, I do. Well, I do family mediation, and I've sort of done family mediation in relation linked to, in fact, a loss of mental capacity of an individual. You see, often, I suppose, the life of a solicitor, particularly private clients' work, is that you are you get very much involved in quite private matters of a family. And we all know that there can be all kinds of issues going on in families that are very private. And as a solicitor, you're taken into confidence a lot of the time. And particularly where there may well be a number of children, it may well be that there are difficulties within marriage. and advice needs to be given. So an example of the family type of mediation is where children, there was no power of attorney in place, and children have differing views as to how a parent who has lost capacity needs to be cared for. That can generate a lot of difficult situation, lots of conflict. And therefore, often it's necessary to have everyone sat round a table and to try to come to a mediated decision. The reason being is that if the family cannot decide how agree how a parent should be cared for, then there will be no option but the matter to go to the court of protection, and it will be a judge who knows nothing about the person who has lost capacity, but it will be his decision and social services as to how the parent should be cared for if the children cannot agree. So it is, as I said, firstly, the first thing is make a power of attorney. Make a power of attorney before it gets to that stage that you decide who makes the decision. Failing that, if there is none, the family should try to agree, come to an agreement, no matter how hard it is, but come to an agreement. Because the very, very last thing to happen is that
You're gone missing at the moment in terms of your
I've
voice.
come back.
Or your...
Sorry, I'm here. I think my picture's coming back. Yeah, sorry. So the very last thing that you want to happen is that a decision about your health, your care, whatever it may be, is left to a court, to social services, to people who know nothing about you, and much less the cost to your estate, because all of this will have to be paid for by your estate. And can I tell you, it costs a lot of money to do so. And it's a continuing cost. From the time that the court get themselves involved in your affairs, it will be a continuing cost until your death. So it is absolutely vital. I come back to saying power of attorney and a will, absolutely vital documents.
So what happens when people can't afford these costs? They have an estate, they haven't done much to sort things out, and the courts get involved and the charges start. What happens then?
Well, if there is no, obviously they'll look at their assets. Decisions will still need to be made, and the costs won't be. There are exemptions depending on if you're in receipt of benefits, etc. But once you have a property, or once you've got any money of the bank, they will continue using those assets until they're gone, and then obviously the benefits system will pay for things.
Poverty by whittling. They'll whittle it away and make you poor. All of your assets go.
Absolutely.
Wow.
And can I say, it doesn't take much. It doesn't take much. I've mentioned already £6,000 to £7,000 a month. And, particularly with, I always think with dementia, thankfully, dementia isn't unnecessarily an illness that kills too quickly. And people can live for many, many years with dementia. And if they're needing to be kept for in a home, a property that seemed very, fortunate to have a £500,000 property, many, many years of £6,000-7,000 a month actually can whittle it down very, very quickly, and the children be left with very little.
I want to say to our American audience, as you view this and pick this up maybe even later, that the principles are exactly the same in America as they are in the UK. The specifics laws may vary, but the principles are exactly the same. You need to think about these type of things also. America will have its equivalent. The Caribbean or Africa will have its equivalent, but the principles are the same. You need to protect your assets with a will and with something like a lasting power of attorney that decides how you are cared for or your property is cared for in the absence of some form of mental capacity. So moving on, how does your work take you into contact with the HMRC, the tax people?
Oh, on a sort of every time I deal with probate, I've already talked about probate, and probate and HMRC are absolutely interlinked. You can't get one without paying the other. It also, it's not just inheritance tax. When you're administering, and that word I haven't used yet, but that process of getting probate is called administering the estate. So when you're administering the estate, it's not just inheritance tax, that's the big one, but you've also got to income tax needs to be dealt with, and on occasion capital gains tax. So, you know, the tax is through everything. And I can't remember who said it, but there is the saying, there's nothing definite in life apart from death and taxes. And that is true. So tax is throughout. So the connections with HMRC are, you know, on a daily basis when dealing with probate, basically.
Okay, so what are some of the things that people generally say when you talk to them about wills and probates? What are their general responses?
I don't need to make a will because I don't own anything, or I own very little, or, oh, well, it will just go to my children. In relation to probate, people don't understand generally. They think if they've made a will, that's it, and which is why I made the point that the will is just a document. It's just saying what you want to happen during the probate process. But yes, I'd say invariably it is, oh, well, I haven't really got much to leave. And, you know, there are circumstances. I should also have mentioned that in relation to probate, that if you have assets less than £5,000 in total, and when I talk about assets, I'm talking about everything you own is valued at less than 5,000 in total, then you don't need to go through probate. It's anything over and above that you need to. But, you know, I know there will be some people with assets of less than 5,000, but nowadays there aren't that many people that fall into that category, thankfully. So yes, so many people say, and what I always say is, oh, I've been meaning to do it for a long time. Oh, you know, it's been on my mind. My oldest client at this moment is 99, who has just made a will. And you know, I am tempted to ask, well, why have you left it this long? But I don't. But 99, and you know, and you're never too young to make a will. And also the important thing is that, you know, once, and I think every time anyone who purchases a property is their conveyancer is obliged to tell them that they should make a will once you purchase a property, but invariably people don't. So, you know, if you're lucky enough to purchase a property in your 30s, or you have children, and that's another important one. Children, young couples with children, in your will, you can indicate who you would like to look after your children in the event that you and your spouse or partner pass away. One of the things we have to discuss when dealing with a young couple is the what if. You know, at the end of the day, you may go away together. Something can happen to both of you at the same time. And in your will, you get to express who you would like to look after your children up until the age of 18. And most of us don't even want to think about that. But by making a will, at least you know that should anything happen, and I'm sure everyone will understand it's not unheard of for there to be car accidents or anything like that where, you know, a couple could pass away, then at least you can decide who in your family or friend network you would like to look after your children, and failing that, they become a ward of the court until that decision is made.
Yes, I can see that clearly. So, what are some of the main issues faced by the majority of your melanated clients? What would you say main issues are that they face?
That they face. By the melanated clients, I would say a lot of them have no idea actually very, very little knowledge, in my mind, exists about planning, about estate planning. They haven't ever thought about it. Whether that's because often I find a reluctance to think about death. Not that I don't encourage anyone to think about death, but the fact of the matter, we know it's going to happen. But there does seem within our community to be a sense that if you don't talk about it, it won't happen. I think the children are also guilty of this, because the children don't want to hear about it. They don't want to think about a parent passing away. And so sometimes I have clients say, I want to talk to them about it, but they tell me not to talk about it. So that type of thing exists. One that is, and I've touched on already, increasingly, and I know there's people from all over on this in this meeting today, but particularly in London and the cities, where our people have bought houses or properties that are now high in value, even though they have very little cash in the bank, but they're sitting in properties that have a very high value. And unfortunately, and I suppose this is one of the big issues I see, unfortunately, the inheritance tax burden on their estate is going to be huge as a result of that. Years gone by, of course, when it was people of colour and melinated people didn't have so much wealth, there were all these tax loopholes, and the wealthy people often would quite easily be able to get rid of their properties quite easily, passing it down without any kind of tax burden. Now, as soon as people have started to, the ordinary folk, so to speak, have become more property rich, now they're far stricter about the tax regime, and it's very, very difficult to avoid inheritance tax. And there's a real lack of understanding within the community about these types of issues, and why it's important to therefore plan what's going to happen for the future. So I suppose those, in terms of wills, those are the types of things. And then in terms of powers of attorney, I suppose just like a lot of families, but even more so, I would say, sorry, just coming back to wills, I suppose what the other thing I would have mentioned is that unfortunately, there are a number of situations where there are children outside marriage that I come across, children of different relationships, and that can cause a lot of complexity, particularly if a will hasn't been made. And I know it applies to all communities, but as I think I touched on way earlier, families where they may have left children back in the Caribbean or wherever, and then come over here and made a new life, and may have a new spouse and may have other children, and not have any contact with children that they'd left behind. They then don't make a will, and then you've got a situation where, someone they haven't seen in many, many years is entitled to part of their estate. And then sort of just coming on to the powers of attorney, of course, I think, as I've said, all of us are finding that as our families age, as our parents age, particularly now living within, the UK or America or what have you, and they're suffering the same types of illnesses as dementia, etc., that mean that, unless they've sorted their affairs out, things become very complicated.
I can see the questions are beginning to mount up. You've got a lot of questions on tonight. However, moving on, I would like to ask you if you could tell us some specific steps of asset protection. What are some specific actions people can take to protect their assets that you would recommend today? You're talking to your friend and you say, you really need to do these things. What would they be? I know you've mentioned some of them already.
Right.
Go ahead.
And I would say these things, and people will initially sort of shy away from it, because, well, and I'll just say this before I go on to say, the fact of the matter is we are all trying to save for a rainy day. Okay, throughout our lives, we're all trying to save for a rainy day. I would say there comes a time, a certain time in life, and it's something I say to people of a certain age, where the likelihood is that rainy day, even if it comes, you're going to be okay because financially you're stable. Therefore, the best thing you can do is not wait to give to your children when you've passed away. It's to give to children and grandchildren if you can whilst you're still alive, because of that 7-year rule that I've mentioned. If you give away, and I know this can be very, very difficult to even think of, you must try your best to reduce the total value of your estate to below the inheritance tax threshold. And that threshold at the moment, I mentioned 325,000, but if you're going to leave to your children, it goes up to 500,000. So you can give away up to £500,000 on your death without any inheritance tax being paid. So the important thing is, if you have lots of cash in the bank, and I know many of us aren't fortunate enough to do so, but it is actually worthwhile, say, passing some of that or sharing that amongst your children whilst you're still alive, and hopefully you'll live for 7 years, and therefore none of that amount is going to then be taxable for inheritance tax, and it will actually reduce your burden, the burden of the inheritance tax on your estate. Also, the fact that each person every year can give away £3,000 without any tax being paid. So you could do a drip feed if you're sort of fairly young and you have children and if you financially you're okay, you can gift it away yearly. You don't have to wait for the 7 years. You can give away up to £3,000 per year. You can give away gifts, as you like, as I said, within as long as you like to live for 7 years. So it's more about, I suppose, the general rule is to say, try, if you can, to reduce the value of your estate, if you are able to, whilst you're still alive, as long as that doesn't mean that you're not financially stable.
All right. Well, my little piece of advice here would be make sure that you write a when I die file, where all of
Oh,
your
yes.
things are there, as to all your passwords, all of your account numbers, everything that your spouse or children need to know needs to be written down while you're still alive, because you may make deals with people and be expecting money that will never come home again because no one ever knew it was missing. You might say, oh yes, you can use this 500,000 to buy your house. Give me the money back when you can, and all that kind of stuff. And that just disappears. There's so much of money that disappears because no one ever knew it was loaned, given, invested, and or those insurance policies, etc. So that would be my contribution to this bit. Make sure you have a when I die file, so your spouse, your children can get in your phone, get in your bank account, get in that encrypted whatever it is you happen to have, and draw on it, or at least have it all listed, so that when you take it to a solicitor, the solicitor can say, okay, we can track down that policy, we can track down that bank account, we can track down those assets, or that house, that's in your name and somebody else's name, they can still find it. Those are things that are very, very important. Okay, what specific ways can we plan better for our ultimate demise as far as you're concerned? What ways can we do? What can we do better than we are doing?
Well,
Especially for
it's
my
all that I've
generation.
touched. Yeah, it's all that I've touched on. It's writing a will. It's a funeral plan. Organising your funeral. That can be done at the same time as you're dealing with a will. If you're still employed, for instance, it's ensuring, or if you have an insurance policy, It's ensuring that there's what's called a nominated beneficiary to pay out that policy. That's an important thing I probably should have mentioned. So if you are, if you're still working, there are some companies, and particularly if you're working in public service, where you will be entitled to a death in service benefit. It's important, if you have such a death in service benefit, that you ensure that you have a nominated, and I use the term beneficiary, so you name who you want to get that amount of money in the event that you die whilst you're still of working age, because that way that money is paid out outside the probate process. Similarly, with an insurance policy, if you have an insurance policy, it's important to make sure you fill in what's called a nominated beneficiary form, where again, you actually name the person you want to get that insurance payout when you pass away. Again, that means it passes outside the probate process. So these are little things that you can do, and you can be planning from whatever age to organise. So it's about a will. It's about using those nominate beneficiary forms, and as I said, it's about looking at your children, looking at what you can potentially give away, even if it's small gifts. So it's just looking at everything in the round and not being scared to take action. As I said, I think a lot of the reasons why people don't do anything is through fear. They're worried that if they give anything away, that what's going to happen if whatever happens. And I'm not in any way suggesting that you give away and then be left in any kind of financial instability. But what I'm saying is there are many families out there, many people of a certain age who actually, even if they're not in a position now, but at some point in the future will be in a position to really plan things effectively. And I suppose the best bit of advice I could say is come and see a solicitor, because that's the best advice. Because at the end of the day, generally, I know for me, that initial meeting doesn't cost you anything. And all it is about is talking through the options for you in your particular circumstances, and giving you ideas as to the things you need to think about, the things you need to go away and do, because everyone's different and everyone's circumstances are different. Everyone's family circumstances are different. And sometimes, a lot of us sitting there and it's weighing us down, what would happen if, or, I'm not on best terms with this child. Even if you, for instance, the type of thing is you have a child who actually isn't doing what you want in terms of a lifestyle, and you're worried about what happens to them when you pass away. Well, we can talk about the type of trust that could be put in place so that you can ensure that they're looked after without actually getting access to the money themselves. So, these are all things that you really wouldn't know or be able to find out about without sitting down with someone who understands the whole area of that type of estate planning work.
All right. Well, there must be some maintenance work involved. You set up these protective regimes. What kind of maintenance do we have to do after we've set things up?
Review every 5 years is what I'd say.
Review every 5 years.
And that, review, and not just every 5 years, but I'd also say every time something happens in your life, whether it be, and it could be as simple as, and you talked about your age group, Trevor. So it could be a point at which you have, and I'm not saying you're anywhere near retirement age, but but it could be that you've decided to give up full-time work. So it's worthwhile looking at your, what your financial situation is for the future and planning for the future. It could be that you've become a grandfather, and you want to now think about have, what's happening with how your grandchildren are possibly going to benefit. It could be that you remarry. It could be anything. Any major major incident in your life, you need to then have a look at your circumstances. And once you're looking at your circumstances, it's not just about writing a will. And this is what I say, it's looking at everything in the whole. Have I got insurance in place? Have I got a funeral plan in place? Have I got a lasting power of attorney in place? The big one, though, is obviously if you decide to remarry, because then that invalidates any previous wills you've written, and you then have to really be thinking again. But failing that, and if nothing really major is happening in your life, at least every 5 years, you ought to just look over that will, because it may well be individuals that you once were very friendly with and you've named as executors. Actually, maybe the relationship isn't as close as it was, and you'd actually like to consider putting someone else in their place. It's that type of thing. So that's the maintenance. It's not hard. And once you've done that major big sort of, review, that sitting down with someone, getting the advice, putting things into place, the maintenance actually thereafter is fairly easy, because it's that first initial action that is going to take a bit of work, and thereafter it's more peace of mind more than anything.
Okay, I want to go a little deeper with you now. Tell us about the kind of challenges that you have had with your clients. So in other words, you're doing all this work, and I'm sure it's not all, like you're saying, smooth sailing. Some of us clients must be very difficult. What are some of the challenges that you come across in your work?
The difficult, I suppose, yeah. It's a difficult one, because I suppose I've become accustomed that everyone is different and everyone wants things a bit different. And I suppose, I actually really, my clients aren't that challenging. Some are, but not that many. But I suppose the type of challenges are wanting, yeah, I suppose this important one, individuals wanting too much control after they've passed away. So you'll often get a situation where a client, particularly when writing a will want all kinds of things to happen. So they want to give a property away, but then they want loads of stipulations within there. And an important thing to emphasize is that a gift cannot be conditional in a will. So you cannot give a gift and then say, I'll give you this. I think one I had was they want the children to have the property, but only if they all come around on a Sunday afternoon to still have dinner. You can't do that, once you've given, you've given. The other thing is, and I suppose what I see quite often is people changing their will very frequently. I do have that quite commonly, because someone's upset them, or a child has upset them, and therefore they no longer want that child to give, or to inherit anything. And then, a year or two later, that child's now back in their life, and they want. So that type of thing can be challenging, but that's just family circumstances. I think, though, in the main, I find, and the way I work is, it's very much about sitting down, usually in their own home, speaking to them and explaining why they can't do what they want to do. And once you really do explain and answer all the questions that people have, I generally find that people are very grateful, and are just grateful to have had that conversation that they've never had before, and have the explanations that they've never had before. And thereafter, I don't really have challenges once I sat down and explained things to them.
Thank you so much for that. Well, what I'd like to ask you next is there anything else you'd like to share with us about the learning that you have gleaned over these many years of experience since you were very, very young, and you're now just, an adult woman, because you've been
Still
practicing so
quite
many
young.
years, but you look so good. I can't believe it.
What have I gleaned? I suppose I find people very, very interesting, and I always have. And I also know that, it's very, very important to listen. I suppose that's one of the things I've learned more than anything, is the ability to listen to people, because often it's what's not being said that is the most important. I'm actually very grateful for the work that I do, and the way that people take me into their confidence, and trust what I say,
Hmm.
and also are happy to take my advice. I suppose for me, one thing I've learned throughout my many, many years, as I said, it's nearly 28 years as a lawyer, is that professionalism is what's important. Honesty, integrity, and professionalism are the most important attributes in my book, because it's obviously professionalism covers all of that. But that's what people want. That's whether it be in the courtroom where I used to prosecute, and it's, what the defendant wants, what the witness wants, is they want professionalism, they want honesty. What the jurors want is to hear the truth of the case, right through to the work that I now do. And what the advice people want is honest advice, and they want it professionally delivered. So I suppose those are, in terms of the skill set that I have. And right from the first, when I qualified, I'm not saying I wasn't honest, I haven't always been, but didn't understand just how important these attributes are, throughout my career. And it's staying steadfast to that, that has meant that I've enjoyed a really interesting and, happy career.
Wonderful. Wonderful. Well, there are people who have not yet taken any action in any of
Mm.
the areas that you have mentioned. So, what would your advice be to them tonight from your experience? What would you like to share?
Contact me. Contact me. No, I would just say, when you go to bed this evening, just think to yourself, actually, I I should get this over and done with. I need to speak with someone in order just to get my will, if nothing else, my will written. Um, Once you've done it, you've done it. You don't need much maintenance thereafter. So if you've taken no action whatsoever, please don't think, oh, well, I'm not old enough. Please don't think that, because what this past, particularly this past year, last year, has shown us is that things can happen out of the blue at any age. And therefore, it is vitally important that all of us as adults are mindful of, obviously ensuring that our families are catered for as best we can. That if you can imagine your family going through the grief of losing you, and then at the same time, really not understanding what on earth you've done in terms of your finances or planning, etc., it will just add to that grief. So I would say start thinking about it, happily picking up a phone to someone like me. And it doesn't have to be me, it can be any, there's a myriad of different people. Lawyers, you can pick up the phone and just have that initial conversation to start you thinking about what it is you want to do for the future planning.
But, folks, I'm going to put my oar in here and say I've known Patricia a little while. We're not known each other for years and years and years, but for quite a little while now. And I found her to be honest, so I can recommend her. So if you want a recommended person, I recommend her. Therefore, next stage is for me to ask people, for people wanting to get in contact with you, how can they connect with you, whether on social media or whether by your business email or telephone number? How can they do so? Please let us have your contact information.
Okay, it's my phone number, my landline is 0208 252 3803, and
Okay.
my email is contact.
Could you give that number again?
0208 252 3803.
3803. All right. Well, I got that. Thank you that time around. Yes, and your email?
And my email is contact. Did you hear me?
No, contact.
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 Richardson Legal Services. Yeah, contact at Richardson. That's my surname, and it's on the screen.
Mm-hmm.
Legal Services.
Mm-hmm.
.co.uk.
Contact at richardsonlegalservices.co.uk.
.co.uk, yeah. And I have a website. My website as well is www. and it's richardsonlegalservices.co.uk, but that is being updated at the moment, so it's best to contact me by email.
.co.uk.
Yeah.
I hope that comes over all right. Yep. I kind of think it. Yep. I think I got it. Think I nailed it that time. Now, I'm going to ask you, Patricia, just to take a moment out to put your light on and maybe get yourself a glass of water for a couple of moments, and I will fill that space. And then we're going to come back and answer all those questions. So for those of you out there who have heard what has been going on, we've been talking about wills and probates, and the number which is of the business for you to ring is 0208 252 3803. If you're from outside of London, it's the same. Outside Europe, you have to put +44 and then drop the 0 at the front. Okay. But I'm not expecting that you're going to ring internationally. You need to now, use some common and apply to your situation in your country. But in a moment, we're going to do our due diligence for you to be able to ask your questions. Remember the email is contact@richardsonlegalservices.co.uk. That's the email address. All righty. So we're going to continue here. We're going to continue. Just take a moment out. And I have to go and drop my pen. Excuse me while I bob down and chase my pen around on the floor. Now it's done. So we have some questions. I'm going to start with the in-house questions because we've got a couple of in-house questions, and we're going to bring Patricia back in just a second. But if you have questions, make sure that if you haven't written them out till now, post them now, please. Post your questions now. At the same time, I'd like to just let you know that we appreciate your involvement in this particular interview, and we thank you that if you're on our YouTube channel, which is called Hebrew Interviews or Hebrew Apostolic, depending on which one you signed in on, that you will be able to make sure you like, subscribe, share, and click the notification bell so that you get notifications of when we are on. But if you're not yet signed up, do sign up. We have many planned interviews coming for the future that will hopefully help you and be a blessing to you. If you're on Facebook, make sure you also share and follow, and make sure that you start a watch party for your friends who might need this legal advice. And also get involved with us. Write to us. You can write to us, HebrewInterviews@gmail.com. HebrewInterviews@gmail.com. If you like to give, look at the streamer down there and give to Hebrew Interviews. Make sure you put the English pound sign before it. On we got you can give by our website, you can give via our Cash App, and you can give, of course, through that thingamajiggy. What's it called now? Somebody help me. Help me, wife. PayPal. Thank you very much. Thank you. Oh, well, I'm just doing that human thing. But we're glad to have Patricia back with us, and we're going to go into the questions. So you're going to have to be brief on these because I know there are quite a few of them have lined up behind, and we don't want to take forever and a day. So let me see now. We have 6, 8, 9 questions, something like that. And they may even get added to. So the first is, do you need to own the house outright before you can put it in a trust? In other words, you're paying your mortgage.
No,
you have
no,
paid off
even if you've got a mortgage. No,
even
you
if you've
don't
got a
need to
mortgage.
own it out, but you may need to get the mortgagor's consent.
Okay, you may need to get the mortgage lender's consent if you don't own the house outright. But if you own it outright, you need nobody's consent. Correct?
That's right.
Okay.
Yeah.
Next question. If there are a couple and one of them becomes incapacitated, and then the other dies and leaves the incapacitated person behind, what happens to the will? So you've got
what happens? So
2 people. One is healthy, the
yeah.
other is incapacitated. But the healthy person dies, leaves the incapacitated person. What happens to the will then?
Well, if the will has already been written whilst the incapacitated person had capacity, then the will stand as it is. So once someone no longer has capacity, they can't change or amend the will. I hope that answers the question. It depends if that incapacitated person has made a will. If they haven't made a will, then they can no longer make a will because you need to have mental capacity to make the will. If they have made a will, then they can't change it because, again, you need mental capacity to do so. So in terms of the healthy person, if it's only the healthy person that has left a will, then the will have to be executed and dealt with on their passing, just in the same way as it would have if the other person was there or not there.
Okay, so if the healthy person passes first, their will is actioned
It's dealt
on
with,
their passing,
absolutely.
but the incapacitated person, the assets still remain with them in their incapacitated state. Is that correct?
Yes, that's right. And that, to a certain extent, you remember I talked about this joint tenancy and tenants in common. That's the type of situation that can occur. So if a couple owned a property jointly and one of them, the healthy person, passes away, leaving the incapacitated person, that incapacitated person will then own the property themselves. And obviously they can't make any decisions around that property because they no longer have capacity. And it could even be that they need residential care and are therefore taken into care, but because they own the property, that property is their asset and is then used to pay their care fees. So that's the type of situation that can occur.
Wow. Wow. Okay, moving on. Next question. Can an ex-husband or wife inherit from your will even though you were divorced many years before? In other words, can they make a claim against your will though you divorced them many years
They
before?
can only though you've divorced them many years, I'd always say in those circumstances, absolutely one of the things you must do is go and make a new will if circumstances like that occur and you get divorced. They can only really make a will, an action, if they were somehow dependent upon you. So usually if someone goes through a divorce, the question is then made, there is a question through the divorce process about a will, but it doesn't necessarily invalidate their gift, any gift that you've made to them in the will. So if you've made a gift to them in the will, a divorce doesn't necessarily invalidate it, but it is a debatable one. I would say if you're going to get divorced or you are divorced, one of the first things you need to do is to make a new will.
Okay, so the claims that are made are dependent upon the will. Is that correct?
Dependency. Yeah. Well, I should have, we haven't touched upon this, but when people ask that question, can claims be made against a will? Any person can make, not any person, but any family member can make a claim against someone's will. They can claim that they're entitled to someone's estate. The question really is, are they likely to be successful? So a husband who hasn't been left anything a will can make a claim against the wife's will. The question is he likely to be successful? And he's likely to be successful if prior to the death of the person, he was dependent upon the death, the person who has passed away. Similarly, children, if they were financially dependent, and financially dependent can be that they were actually living in the house of the person who has passed away prior to the death, then there is a likelihood that they will be successful with any claim. So as I said, the question isn't can they claim? Yes, they can claim. The question is, are they likely to be successful? And that will really depend on circumstances.
Okay, so get them out the house.
Yeah.
All right, moving on. Next question. If your solicitor is named as a firm or their firm as the executor of the will, what percentage can they take from your estate?
That will be dependent upon their fees. There's no hard and fast rule. Solicitors charge varying amounts of fees. It's not just solicitors. Sometimes banks are named as well, and that should be something when you initially have the will drawn up that you speak to them about, but they will be able to charge what their current fees are at the time that you pass away and they need to deal with probate. My advice, and I know there are circumstances where it is important and helpful to have a professional person. If you can, it's helpful to have a family member working alongside the solicitor. And the solicitor, often the way things are dealt with is that if the family member feels that they don't want the solicitor to act or to assist them, they merely need to ask, and solicitors will step aside if they feel that they should. But in terms of fees, I can't say exactly how much it should be, because there is no standard fee. It depends upon the firm and what their charges are at that current time. But the fees a solicitor charges, just ringing up the firm and asking, should be sufficient to know how much. It can often be as a percentage. So it can range from 1.5% right up to 5% of the total value of the estate.
Wow. Okay. Next question. So if you pass away and leave your adult children in the property, are they expected to sell the property for inheritance tax purposes and therefore be unable to stay in that property?
If they do not have the funds to pay the inheritance tax, then the likelihood is that they will have to sell the property in order to pay the inheritance tax. And once paid, whatever's left.
So what if the property is valued at less than 325K?
Well, there'd be no inheritance tax to pay.
All right. So there you have it, folks.
We're only talking about a situation, and it could be if the property was valued at 400,000. In fact, if you've left it to your children, as I'd said before, you can at the moment give away up to 500,000. So if the property was worth 550,000, 500,000 pounds worth of your total value of your estates would not be taxable, and tax would only be payable on the 40% of the extra 50,000, which would, be 20,000 or something. So they may be able to pay that or raise funds to pay that. What I should have also mentioned there is that if there is a mortgage outstanding on the property or you have other debts, those are paid off first. So it's your net estate that is taxable.
Okay.
Not your gross estate.
All right.
If you had a 500,000 property, yet you had a 200,000 pound mortgage, then actually it's going to take you below the threshold of 325,000.
Okie dokie. Moving on. Can someone who is married but's been separated for many years and was initially married abroad, so their marriage is not registered in the UK, can they still make a claim of inheritance or claim to the right of a spouse for the inheritance?
Well, that's an unusual question. The marriage abroad, even if it's not registered here, what is important to understand is that the UK do actually recognise marriages that have occurred abroad as long as the marriage has occurred or taken place in accordance with the laws of that country. So the fact that it may not be registered here doesn't mean that as far as the UK, it is not recognised as a legal marriage, as long as it generally, and I should say generally, because I'm sure there are circumstances where this may not be the case, but generally, as long as the marriage abroad has taken place in accordance with the laws of that country, then in the UK, it will be treated as a legal marriage. And as a result, they will be regarded as the spouse of the UK resident who has passed away. And if a will hasn't been made, or if a will has been made, and they may then be able to have a legitimate claim against the estate.
So make sure you have a marriage certificate, properly notarized, etc., no matter where you got married.
Yeah.
Moving on. Can you downsize if you own a large, high-value house and buy your children a house of their own will they still have to pay tax on it?
So if you have a large, house and you
You have a
sell that
family house, high value. Would it be better? I think the question is to sell it off, downsize, gift your children money so that they can buy their own.
Yeah, yes. And as long as you survive for 7 years, then there will be no inheritance tax to pay on the value of that property. Of course, if the rest of your estate is still worth $1 million. And one of the things, just to make it important, I know we keep talking about property as in a house or land. Actually, property in relation to the legal way of talking actually relates to anything you own. So when I talk about values of 325,000, that's your total value of your estate, including property, including money in the bank, including, you know, anything else that you own.
Shares
So
and
that
insurance
situation where,
policies.
yeah, so that situation where someone owns a large house and yes, if they're able to, they could sell it, downsize, give their children money to buy their own property. And hey, you know, they've now got a property that's only worth 300,000. So that's fine. That's below the tax threshold. But if they've then got 600,000 in the bank, actually they're still going to be subject to inheritance tax, obviously far less than had the property been worth £1 million, but they're still going to be subject to inheritance tax because it's the total value of your assets.
All righty. I've got one last question. Can you put money in trust for an adult child or an adult dependent?
Yes, and it is in my mind, this is the best use of trusts, particularly if you've got an adult child that may be disabled, an adult child that may, and I think I touched on before, have health issues in relation to some form of addiction, adult child that is spendthrift. Those are the types of situations where trusts actually are really worth their weight, because you can then ensure that they are catered for, but never actually get direct access to the money themselves. You can then leave it for your trustees, who are people you trust, to ensure that the money is used for your children's benefit without them actually getting access to it and using it for reasons that you wouldn't want them to. So yes, you can.
Wow. Well, we've done some great work tonight. I feel like we've added value to our community. So I want to ask you, are there any other projects that you're involved in that you might like to share at this time?
Any other projects? Projects like, well, in terms of career-wise, are you talking?
Anything that you're involved in, you know, maybe charity work or otherwise that you want to share that
Oh,
you're
right.
involved in?
Yeah. I am. I'm all. I'm also, along with Trevor, actually, a
You
trustee.
weren't supposed to say that bit.
Oh, sorry. I'm also a trustee of a charity, and also I'm a member of a fitness to practice committee for certain professions where people who find themselves in disciplinary situations have to come before a sort of a hearing. So I do that work. And yes, the charity for the elderly African Caribbean community, I'm a trustee and treasurer.
Oh dear, you're giving away my little jewels. Never mind. Okay. So, are there any parting words or information you'd like to share before we close?
Just that, you know, thank you first of all for inviting me. One of my missions is to make sure that melanated people get the best advice they can, because, you know, most of us are working very, very hard, trying to do the best for our families. And we need to get the best advice that is going to ensure that we equip our families for the future and put them in the strongest position that we can, in order to ensure that the next generations do even better than us. So, you know, I'm very much glad that I've been able to speak to you, and I will continue to go around, as I do, to many organisations where particularly our melinated people congregate, to spread the word of, you know, getting advice. Financial planning, estate planning are absolutely crucial for us to make progress in the future.
Okay, would you restate your telephone number, which is showing on the screen anyway? Just restate that for us.
It's
0208
0208 252 3803.
and your email, please.
contact@richardsonlegalservices.co.uk, and it's on the screen there.
Well, I want to thank you for your time, Patricia Richardson, solicitor. We appreciate you being with us, and we appreciate you, audience. We thank you for your support, whether your viewing support, your financial support, and your prayers. Very important to us, and I hope that you have found this particular session to have been valuable, and that you do give Patricia a call if you have that need, or if it comes to your mind, and if you have any more questions, why not connect with her? And of course, ask those questions. Take that counsel. What's that? That session call that is free again? That first session?
That first session is free. You can get some advice.
Consultation. That consultation. It's valuable time. But after that, you're going to have to and of course, that's where you show the love. We have, you will benefit from mutual service. So you serve the person that serves you. We want to say thank you. Stay with us, please, Patricia. But for everybody else, we want to say thank you for being with us, and we appreciate you. Look forward to seeing you again soon on another session of Hebrew Interviews.